Good morning, everyone. And on behalf of Vidyapeeth College, Pune, Environmental Cell, I welcome Advocate Padma Shri Norma Madam and our Principal Bharati Deshpande Madam, all the faculty members and participants. Now I request our Madam to address the gathering.
Hello, good morning everyone and welcome to the Enviro Legal Online Lecture Series. Honorable Dr. Pattanarauji Kadam, the founder of Bharati Vidyapeeth, deemed to be university, a man of mission and vision, has founded this university on exceptional fundamentals, social transformation through dynamic education. This mammoth and massive task is today handled by our beloved Chancellor, Honorable Dr. Shivajirao Kadam and Honorable Dr. Vishwajit Kadam, Pro Vice Chancellor and Secretary of Bharati Vidyapeeth, who is also the Minister of Maharashtra for Social Justice. Bharati Vidyapeeth, deemed to be university, is a university of high repute and has got a class of its own. It has been ranked 67 by the NRF and has got many flourishing units under it. New Law College is one of it. The New Law College is consistently ranked among the top 10 law colleges of India and is always known for the innovative practices. This college has various cells, that is, apart from the syllabus and the curriculum, we have various cells established to further the process of education, that is the practical application of the principles and the concepts. There are the cells like the Madhyastha, that is the ADRS cell, which has started a new platform, a global platform of Guidera, and the educative system is such that on this platform, we are every day uploading certain videos and lectures regarding the arbitration national as well as international. We have a legal research cell, which helps the students to conduct the research. We teach them the principles of research methodology, the article writing, etc. We also have a legal aid cell, which gives legal aid in all perspectives. It's not only just matrimonial disputes, but even the cyber crimes and the other various social issues. It has won the Best Legal Aid Center Award last year. We have also Environment Cell, which is conducting today's program. The object of Environment Cell is this, that the people, the society should be aware of the environment first, the environment pollution, and the steps to be taken for protection. Now, the concept of environment pollution is such that it cannot be handled by any one section of the society. It requires a collaborative effort. And that is why the mission of this Bharati Vidyapeeth New Law College Environment Cell is to bring awareness, because the people should be aware. Just saying that the state should take care of the environment pollution and protect, it will not be done, because the state will enact laws. But who will follow the laws? And unless and until the laws are followed, how will the environment protection be successful? So, in furtherance to their objective, we have conducting this Enviro Legal Online Lecture Series on this very auspicious day of Gandhi Jayanti as well as Lal Bahadur Shastri Jayanti. And today we have none other than the Padma Shri to inaugurate this lecture series. My dear friends, this lecture series is going to be profoundly helpful because it is going to include various dimensions like today's environmental impact assessment, tomorrow's waste management, because this is the crucial aspect of environment protection, how to manage our waste and how to see that the waste does not further the environment pollution. And the next day, we have the laws relating to the forest and the tribals. What is the impact of these laws on the tribals? We concentrate on the animals, the wildlife, but these laws also have an impact upon the tribals. So how to balance the both? So this three-dimensional Enviro legal series we are going to start today. And I hand over the mic to Jyoti, Dr. Jyoti Dharam, who is the head environment legal cell, along with the chief coordinator, that is Dr. Jayashree Khandari, to further. Thank you so much.
Thank you so much, ma'am. You are always a source of inspiration for us. Thank you so much for addressing the gathering. It gives me immense pleasure to introduce today's guest, Honorable Advocate Norma Alvarez, ma'am. Ma'am has completed her law from St. Xavier's College, Mumbai. She is an activist, a campaigner on social and environmental issues of public concern, and a founding member of Goa Foundation. Ma'am, while being a member of the same, ma'am initiated a PIL in 1987 to save sand dunes in Goa, and it was the first ever PIL in the state. Her efforts reported in winning a favorable court order for blocking a DuPont factory and another one which restricted the mining activities in Goa. She has been involved in more than 100 PILs, in which mostly were related to environmental issues. She is a chairperson at Federation of India Animal Protection Organization. She was instrumental in obtaining judicial orders banning the killing of stray dogs and the cruel sport of bullfighting in Goa. She even started the Goa branch of People for Animals. Ma'am was honored by the government of India with the fourth highest Indian civilian award of Padma Shri in 2001, in 2002, and Yashadamani Puraskar in 2001 by Government of Goa. Ma'am has tirelessly fought for environmental pollution, animal rights, and women's issues. Now, I request ma'am to address the attendees on the topic environmental impact assessment.
Thank you so much for that wonderful introduction, which I don't know where you have found from, but well, many things were correct. I am happy to participate and to inaugurate this environment series of lectures. It is truly an auspicious day because it is Gandhi Jayanti, and Gandhi spoke for cleanliness, for truth, cleanliness of the environment, cleanliness in public life. At the time when Gandhi was alive, at that time, environment was not a big word. There were no environmentalists. But you can say he was an environmentalist, definitely, because he believed in small. Do not leave a very heavy footprint on the earth. Do not let your footprint be light, which means don't damage the earth with big industries, with big projects, which the earth cannot bear and cannot carry. But today we have forgotten a lot of his values, and environmentalism has become instead the O Courant word, which only shows how far away we have come from Gandhian principles and how much we need to restore our own attitude towards the environment and nature around us. Well, I will go straight to my topic, which is Environment Impact Assessment Notification. But considering that this is the beginning of an environment series of lectures, I would like to give you some background into environment law, which will help you to understand the forthcoming lecture of municipal solid waste management and so on. So environment law in India began with the Stockholm Conference of 1972. It's an international conference, very well known, attended by heads of government from countries across the world. And India's Prime Minister, Mrs. Indira Gandhi, played a very, very crucial role as a champion of environment law and as a champion of protection of the environment. The Stockholm Conference resulted in the Stockholm Declaration, which had 26 principles. I would like to just mention 5 of them for you. One is, man has a fundamental right to freedom, equality, and adequate conditions of life. So when you live, it's just not your life that you are alive, which is important, but you must have adequate conditions to make that life meaningful, which means you must have food, shelter, good health, water, etc. Basic principles. Another principle is man has a duty to protect and improve environment for present and future generations. Man is the word used at that time. It means human beings, all of us, men, women, children. We have a fundamental duty to protect the environment, not for our own selves, but for future generations. And in line with this, the Supreme Court enunciated the principle of intergenerational equity, which means don't exhaust everything today, keep some for tomorrow, for the next generation. Another principle is the capacity of the earth to produce vital renewable resources is limited and must be used judiciously. What does this mean? We have resources which are non-renewable, say minerals, coal, etc. This is the quantity which is there, and if it gets over, it's over. But even the renewable resources, the one which comes every year, like rain, like our water, like air which is renewed, there is a limited capacity. You simply must not finish it all. You must use it judiciously, with care. Another principle is the earth cannot withstand damage beyond a point. We think that, well, maybe we can damage it today. There will be the monsoon. It will clean up all the mess and we'll get a brand new earth again. But that is not entirely true. If we damage beyond a point, it cannot resurrect. So many of our animal species have vanished. We can't bring them back. No, I'm not talking about the dinosaurs. I'm talking about things which were yesterday around. How little we hear frogs nowadays, for instance, because we exhaust. Look at the fishing scene where fish is exhausted. It's overfished. There is a famine of fish, in fact. So you cannot damage the earth beyond a point. It cannot come back. And the last principle I wish to mention is development must be balanced with environment protection. You do development, build your cities, build your urban areas, put your water pipes, put your mobile towers, but remember to balance how much development you want with protection of the environment. Now, immediately after the Stockholm Conference, there were two major laws introduced into India. One is the Water Prevention and Control of Pollution Act 1974, which, as the name suggests, was to prevent water pollution and to control the kind of effluents which would go into it. That was followed in 1981 with the Air Prevention and Control of Pollution Act to protect the air around us. But then came the Bhopal disaster, 1984, a huge disaster which left India shattered because overnight, more than 3,000 people died in one night from the gas fumes of the carbide factory. And this set the government thinking that the two acts, Air Act and Water Act, were not enough. Because though the acts were there, how did this disaster happen? And so government did a rethink, and that led to the framing and the notification of the Environment Protection Act 1986. Now, the Environment Protection Act is a unique act, and I'd like to mention three features for you. One is it is an umbrella legislation, meaning if anything in the environment is not covered by a specific law, it will be covered by the Environment Act. Look at the definition of the Environment Protection Act. It is defined, what is environment? Environment is defined as air, water, land, and the relationship between air, water, and land, and human beings, and plants, and animals and microorganisms. There is nothing left out. So it's an all-encompassing, powerful act. Secondly, Section 24 of the Environment Protection Act has an overriding clause which says, notwithstanding anything contained in any other law in a state, the provisions of the Environment Protection Act will prevail. So there is a state act which says this is the norm and this is the penalty, and that conflicts with the Environment Protection Act, then EPA will be the norm. You cannot say the lesser act is followed in our state. Not possible, because Environment Protection Act, EPA, applies throughout the country. And the third important thing to note is that Section 5 gives the central government, and by delegation the state government, power to close an industry and cut off water and electricity for violation of the act. Any provisions are violated, company is not behaving, you can cut off its lifeline. For a factory, for an industry, its lifeline is water and electricity. If it doesn't have these two things, it cannot function. It is probably not an industry then. So these are powerful provisions which were brought in. Later on, the power to cut off electricity and water act was incorporated into the Air and Water Acts as well. So EPA is the basic statute, but EPA is implemented through various notifications. EPA gives you the broad principles. It is implemented through a series of rules, regulations, notifications. Coastal regulation zone notification is one of them, applicable to coastal areas. Municipal solid waste rule or solid waste management rules, which you're going to hear about tomorrow, is another of the notifications. Hazardous waste rules and EIA notification, which I will deal with now. So EIA, short form, it means Environment Impact Assessment Notification. What is its purpose? The purpose is to identify the impact of a project or an activity before it is constructed in advance. We want to identify what will be the impact of a project or an activity before it commences. What could be a project? A construction of a factory, construction of a bridge. What will the impact be on the environment? What is an activity? Dredging of a river, mining. These are not buildings. You're not building, you're not constructing anything. These are activities. So both projects and activities which the government considers as can have an impact on environment would fall under the EIA notification. What is the reason for it? We want to know what the impact of a project or an activity would be in order to ensure that the negative impacts are within the carrying capacity of the environment. Any factory will emit smoke, it will have effluents, it will have solid waste. It cannot be, even you and me, we have some impact, but our impact is not serious enough and it is organic. Whatever we throw out from our bodies, that the earth accepts. But chemicals is something that the environment cannot necessarily deal with. And therefore, you want to see what negative impacts will be able to withstand the carrying capacity. What is a carrying capacity? As I said in the beginning, you do something, but within limits. If a father takes a stick and beats his son, maybe one slap will do no damage. Maybe two slaps will do no damage. You do 100 slaps and see what happens. Your child will faint. You'll have to be rushed to the hospital. You have gone beyond carrying capacity. So carrying capacity means that the earth can take so much, but not more. And an industry or an activity must be allowed only if it is within the carrying capacity. So does every project have a negative impact? Well, every project will have some negative impact, but there are certain ones which will have great environment impact, and we need to know these in advance, so that, for example, industrial units, townships, bridges, roads, they will have impact. So why do we need to know this in advance? Why not wait for it to start and then let's see what happens? If it is bad, we'll shut it down. But well, industry doesn't work that way. The proprietor will say, I've invested my money, I've bought my land, I've done so much of work. Now you can't tell me to shut down. What happens to my workers? Where will I go? What happens to my investment? So we want to know in advance, so that, number one, there can be mitigation measures. The government can say, well, don't do this part, don't do production to this extent, don't use this equipment, do this, do that. Or the government can reject the project. It can say, sorry, we can't allow this project, it is too harmful for the environment, please don't do it at all. Or the government can frame standards. It can say that if you're going to run a cement factory, well, this is the standard of emission. This is the standard of water effluent. This is the standard that you are allowed, but don't you dare exceed that much. So this is the reason for asking for a EIA, because it is based on Supreme Court's another principle, the precautionary principle. What is the precautionary principle? It means that if you think something is going to be wrong or going to be harmful to the environment, well, stop, study it, take a look, go ahead only if you're confident. Don't say, there's no science about this, nobody knows what will happen, maybe nothing will happen, maybe it will be all right. No, if there is a doubt, take a step back, take a call on whether that activity can happen. You know, when you go for sports, if you have to jump a high jump over something, you take a call, no? You say that, can I do it? If you think you can't do it, you'll say, bring the bar lower. I can't do that. Same way, precautionary principle is another Supreme Court principle which it has enunciated for the law of the land. So how does the EIA notification work? The project proponent, you'll hear that word in the EIA notification. Project proponent means the person who is proposing or advocating that project. That project proponent must engage an agency to do an environment impact assessment, which means that all the data about the factory, or let us take factory for the moment, all the data about the factory and all the data about the surrounding environment must be given to that agency. That agency is, the ministry has got a list of agencies. That agency will study the correlation and so on, what you're going to emit, what you're going to produce, how you're going to handle, where you're going to go, how the transport will be, what will happen, etc., etc. And it will make an assessment of your project, which is an environment impact assessment. That EIA report will be sent either to the central government or to the state government. How will you know where it has to go? Because the EIA notification has a schedule of activities and projects. There's a list, 30 project stroke activities. Now that list also says that these ones will go to the center and these ones will go to the state. Big projects which will impact a couple of states, large amount of disruption, huge quantities, they all go to the center. When I say center, I mean Ministry of Environment and Forests and Climate Change. That is the nodal agency for the entire project, but for large projects, the EIA report goes there. In the case of the states, it will go to something called the State Environment Impact Assessment Agency, SEIAA. So once the EIA report is ready, it goes to this agency. Whether it's center or state, they both have an Environment Assessment Committee. EAC at the center, SEAC at the state. That committee now will look at the EIA report and its own experience, and it will make a recommendation to the Ministry of Environment, or in the case of the state, to the SEIAA. And the Ministry of Environment or the SEIAA will then decide whether to grant an environment clearance, an EC. That is the objective of the EIA notification, to grant an environment clearance to a project saying that, yes, this is an activity which will not violate the carrying capacity. It has negative impacts. These are the measures to deal with this impact. This is the standards to be followed. And there are a whole set of conditions and regulations which go with your environment clearance. Once you get the environment clearance, then you approach your local government, state government, municipality, panchayat for your construction license and for whatever other documents are needed. Now, the EIA first came out in 1994, the EIA notification. And this was what I've explained to you just now, was the format for the 1994 notification. Very important is that the EC must be a prior environment clearance. You cannot even put a pole or dig a ditch or do any construction work, no leveling of the land, no nothing until you got your EC. So it is a prior environment clearance. The only thing you can do is paperwork. It means that if you have to apply to somebody for the document, you have to sell the land, you have to buy the land, you have to pay somebody, you have to find people who will support your activity, raise funds, you can do all that. All paperwork you can do, but you cannot do anything on the land at all before you get your environment clearance. The EC in 1994 had a standard 5 years. It was granted for 5 years. After 5 years, you come back, except if it is construction of a building, because you can't come back after 5 years and say, your building is constructed, so what are you going to do? So the construction would remain, but the activity had to be renewed. The EC had to be renewed every 5 years. Now, this EIA notification 1994 lasted for 12 years until 2006, when the second EIA notification came up in 2006. So, the 2006 EIA notification was a fresh notification in place of EIA 1994. It was new and it was much better in many ways. But the basic principles were the same as 1994. So I'm not going to explain it all over again. Everything was the same: center, state, SEAC, SEIAA, getting an EIA, etc., etc. Everything was the same. There were, however, some very good new features introduced, which I will concentrate on now. Firstly, the EIA 2006 introduced public hearings. Now, what is a public hearing? It's what the word says: a hearing of the project by the public. Who is the public? The notification said affected people and those who have a stake in the environment. So who would be affected people? Naturally, the people around. They are the first people to be affected by a project. They have their homes, they have their school, they have their roads, they go to work, they come back, they use the same roads. And you have now suddenly a big industry coming up. It will impact them. So they must know about it. They must know whether they like it or they don't like it, and not like it in the sense of I like cement and I don't like cement, not that way. Whether it will affect them in what way. Who are those who have a stake in the environment? Now that word, that phrase was interpreted by the NGT, I think, to say that it was inclusive of anyone who wanted to say something about that project. And it included NGOs. Now, NGOs, the government today is very wary of them because NGOs, they say, create a lot of problems for the government. Where NGOs also bring out a lot of negative aspects of projects, of activities. NGOs champion the rights of downtrodden, poor people, etc. So the NGT said, we will make the word those who have a stake to be broad. We will not say, oh, you are living in Pune. What business you have got in Goa? There's a project here. Why are you come? Well, you can prove that I have done a study on this particular subject and I therefore wish to be heard in this matter. That is a possibility. Or even close by, there could be another industry who, another NGO, sorry, who could say that I know the impact of this industry in my village in North Goa. So I want to say something about what will happen in South Goa because these people may not know it. Therefore, affected people is a very broad term, all of whom have got the right to participate in a public hearing. Now, the EIA invariably would be in English. So then it was, the NGT said that even the law says it must be in the local language. How do you expect people who speak Telugu, if they don't know any English, to be able to comment on the EIA? Those who speak Konkani and have not gone to school and college, how are they going to comment? Give it in the local language so that they can understand. If they can't read or write, that's a different matter, but at least to the best extent they can understand. Second, give notice of a public hearing. Don't put in the papers tomorrow and don't say, oh, tomorrow is a public hearing. Those who want to come, come. No, you have to give 3 weeks notice at least. Put it in the newspaper, widely read newspaper, so that people understand. And the hearings have to be conducted by the collector. Why the collector? Because the collector can call the police if there is trouble, if people are fighting with each other, if the company goes and brings 100 people from its side to say, shoo, shoo, no, down, down, you're wrong, this, and a big fight takes place, then they do something about it. So collector is also a neutral person. And after this public hearing is held, and I must tell you that in Goa, when they held a public hearing on transportation of coal, the public hearing went on for 8 days. It is one of the longest public hearings which took place because there were lots of people who wanted to have their say, and you could not say, sorry, you're saying the same thing. No, you gave your name in writing, I want to speak. You were given a chance to speak. 8 days public hearing. Usually public hearings finish within the day. After the public hearing is held, before that, in a public hearing, what is the importance is that incorrect facts that the EIA report may contain come to the forefront. If the EIA report says there is no architectural monument close by, because architectural monuments are an issue with a grant of environment clearance. You can't do something close by. Or there is no forest close by. If the EIA report says that, that means the company has given wrong data to the EIA agency and the EIA agency has not bothered to check anything. In a public hearing, the people will say, excuse me, Taj Mahal is only within 5 kilometers of this place. Can you think about it? Or some statue or something of heritage, whatever is there, you come to know. So incorrect facts come out in a public hearing because people are living there. It's not that they are studying, saying something about Europe which they have not seen. They know where it is. They pass by every day. So these facts come out. Lacunae come out. and concerns. We are concerned about this problem. We are concerned about that problem. We already have got so much of pollution. We're going to add one more to it. Then what will happen? All these concerns come out. This public hearing, a report has to be made by the collector, and that report then goes to the central government or the state government. And there it is that the EAC or the SEAC, they now study the EIA and the public hearing. And then they look at it and they think and they say, well, this fellow missed out a lot of stuff. Send it back. Tell him to do a fresh EIA. Or they may say, okay, now there are a few things, but they are not so important. And they make their recommendation, as I told you, going to the central government ministry or to the state EIA. Now, the EIA 2006 also introduced a sort of regulated form, 5 stages to the acquiring of an EC. Number 1, screening of the project. Screening meant before you do your EIA, the project is screened by the local authority to say that, okay, carry out these studies, do an air study, do a water study, do a this study, do a that study, whatever. They list the number of studies. Then secondly is scoping of the project. Scoping means what is the possible impact, and therefore the scoping exercise draws up terms of reference, TORs, which means that the project proponent has to take the TORs and go to the agency and say, please do your EIA in terms of this. They want to know these facts. So there are terms of reference given. Third stage is public consultation. Fourth stage is appraisal by the committee, which I told you, where the committee considers both the EIA report and the public hearing. And fifth stage is the decision to grant an EC or reject the project altogether. The EIA 2006 also introduced post-EC monitoring, which was 6 monthly reports to be given to the government on what is happening on the project. And finally, the EIA notification 2006 changed the validity terms. It made it range from 5 years to 30 years. So you could have 5 years, it could be a 10-year project clearance, it could be a 12-year clearance, it could go up to 30, which was very rarely given. Now, I've given you all the good points of the EIA notification, but its functioning had certain drawbacks. Though it is, I have spoken for the government, so to speak, telling you how good the EIA notification is. The fact remains that the EIA notification is a very good notification, but in implementation, there were certain drawbacks. Firstly, you must know that the EIA notification is an enabling notification. What is the meaning of enabling notification? It means it enables you to do the project. Unlike, let us say, the CRZ notification, which says, don't do in the CRZ area, don't do here, don't do there. That is a prohibitive notification. But enabling notification means that if you come up with a project, they won't tell you don't do the project. They will tell you, well, if you want to do this project, then you must reduce the quantity, you must put this equipment, you must do this, you must do that, you must do the other. So it helps you to do a project. So I don't know if I can even recall, very rarely does the EIA notification say this such a project cannot be done at all. Mostly it enables the project proponent how to do it by making changes in the project. Secondly, there is no scrutiny of the people's right to the resources of their area. For example, in Goa, I'll give you an example of a case I dealt with. There's a beach and there's a village behind it. And there are already 2 hotels on that beach. And a third one and a fourth one were to come up. So they went for environment clearance. Now the people said, we've already got 2 hotels. Those 2 hotels are already creating problems for us. There's so much of traffic, there's so much of people, the road is narrow and so on. We don't want any more projects. We want the beach. But that the EIA notification doesn't say that. People want the natural resource to be used in a different way. The EIA notification looks at the project and says, well, it is possible for you to construct this year, so we will grant it subject to X, Y, Z. So there's no way in which what people want, the EIA will consider. Thirdly, the EIA reports, the environment impact assessment reports, are done by a list of some 10, 15 agencies. And they are what you would call, in mild words, friendly agencies. You see, they don't say, no, this is a bad project, utter rubbish, it will destroy the environment. I'm not going to give you a favorable report. Or if they give an unfavorable report, what will the project proponent do? He'll go to somebody else because he's not obliged to bring that report in the public domain. He'll pretend as if no such report ever existed. He'll go to somebody else and say, you do me an EIA. And then when he gets a good EIA, then he will say, now I have completed my EA and I will bring it into the public domain. So all the EIA reports always are in favor, and they suggest certain measures and they make certain recommendations. But I have yet to see one EIA which says that I have assessed this project, it is very bad for the environment. No such report I have ever come across in my 30 years of practice. Fourthly, very important, there is no cumulative assessment of projects. I gave you the example just now. I told you that there are already 2 hotels on the beach. The third fellow comes for an environment clearance. Should not government assess the cumulative impact, which is what the people are complaining about? They are saying we already have 2, please don't put 1 more. But this project proponent will say, I am following the laws, I am doing this, I am following all your standards. But there is already pollution in the air and you're going to add to it in the case of factories, for instance. So a cumulative assessment is not done. There's a very striking example in Goa currently. We have the Bhagwan Mahavir Wildlife Sanctuary. The ministry has approved of 3 projects. Expansion of the roadway, expansion of a railway line, and a new transmission line to go through the project. According to us, this will finish the sanctuary. Each one is being assessed on its own. Oh, this is the road, okay. This is the railway, okay. So 3 projects are, some of them have got and some have yet to get, but they are not being cumulatively assessed on the impact that 3 projects will have on a sanctuary. This is very, very bad. I mean, what kind of assessment is being done? Each fellow has gone to a different agency and each fellow has assessed it as if he's sitting in an ivory tower with a very clean slate and he has made some few drawings on it. That's not the ground reality. Another negative feature is that there are ways to defeat the EIA notification. For instance, the EIA notification says that if a project is a road project is 100 kilometers in length, then an EIA is required. So what did the Goa government and what did the central government do? It made the project into 2 parts. In Goa, it is 83. In Karnataka, it is 65. So together, it comes to 150 something. But individually, they are not required. And they went to the court and they said, we are not required individually. Karnataka side went to Karnataka court. Goa side has not yet gone. But Karnataka court, the judge was very smart. And he said, what is the total length of the road? Then they said, well, in Goa, there is this much. He said, does it join? They said, well, yes, it does join. But there's a state boundary. The judge said, sorry, it appears to us that the road is a total of 100. The environment doesn't break up, when you move from Karnataka to Goa, it's not that there's a big wall. So he said, I don't think that I can allow this as yet. So these are ways in which you look at the standard. If it says 10 kilometers, you just make yours 9.90. So these are ways to sort of run away from an EIA. And the last thing I'd like to mention on the negative impact is that errors in the project proposal are generally overlooked. In the case of a Mopa airport in Goa, the EIA said that there are no trees, there are only bushes and scrubs. But the forest department later gave permission for felling 55,000 trees. Now, this was a complete lie of the EIA notification. It went to Supreme Court. Supreme Court sent the EIA back and said, the EC back and said, ministry reconsidered it. So the ministry reconsidered it and gave the clearance eventually based on the fact that 55,000 trees were now cut. So these are the negative impacts of the EIA notification. I've got a little more time. So let me tell you now, the EIA notification 2006 has lasted until the present year. And in 2020, central government has issued a draft EIA notification 2020. Now, this draft notification is horrid, to say the least, for a number of reasons. But it is not my view only. 17 lakh people have written to the central government opposing the EIA 2020. And the EIA notification 2020 is so far only in English. The Delhi government has said, publish it in 24 Indian languages, let everybody read. The Bangalore High Court has said, until the publishing is done, no finalizing the notification. So right now it's stuck. But there is a lot of opposition to the EIA 2020. And these are the reasons for the opposition. First and foremost, the notification name remains the same. But in the objective, it states that the purpose is for ease of doing business. This is the first time that you are having an EIA notification, an environment impact assessment notification. Why? So that business can have it easy. Now this is completely opposite. The whole point was to make business difficult, was to make business subscribe to certain norms. But what are you doing? You're throwing out the norms so that he can get an environment clearance quickly. Now that's like saying, okay, I mean, right now all students are passed and okay, you get your certificate. But there is no standard, there's no impact. And while in education, maybe from class 5 to class 6 to class 10 to 11, this is the whole environment is at stake. So the purpose of it says in the notification that industry is very upset that it's taking so long to get all these things done. It's for ease of doing business. Of course, they have tried to gloss over it by saying that we do not want delays. But the whole point of delays is because you've got to study something. You cannot give a clearance if you don't study it. So that is one purpose. Second thing is that many projects are exempted. Either the projects are exempted from getting an environment clearance, or the levels and the standards, the limits have been raised so that many fall out. It's like saying, instead of 35, instead of first class being 60% of the marks, we will now make first class 40% of the marks. What happens immediately? Whole lot of more students get first classes. Of course, in industry, the way I'm explaining, it's the opposite, but this is the principle. You raise the limit or you lower the limit, industries fall out and they don't have. So you might have coal as requiring, you might have mining as requiring an environment clearance, or coal, or these mega projects or townships. But if you raise the limit, then they are smaller than that, so they don't need an environment clearance. Thirdly, they have made it very complicated. And they have made it so complicated to confuse everybody and complications. The 1994 was a simple, straightforward notification. It was very easy to understand, very clear. You are either right or you are wrong. You either fall in it or you don't fall in it. But if you make a clause that coal will be subject to it, however, the following exceptions, if this, if that, then it becomes extremely complicated and allows industry to negotiate between the lines. For instance, it has made category A, B1, B, and B1. And it says that if you are in B1, you don't need a public hearing. Why? The project is there within the EIA notification. It requires the clearance. Why are you cancelling the public hearing? And they've put into B1 all the problematic ones where they have experienced problem over the past years. They put them in B1 so that none of them requires a public hearing, which means the public is not supposed to know what is going to come to their areas. The fourth thing is that they have extended validity in some cases up to 50 years. Now, 50 years is actually a lifespan. I'm not saying you live 50 years, but the adult years of yours, the years when people can comment, can take part in public life, can say something, you get about 40 years or so, because you are studying, you're a child, you're a baby, you grow up, you run around after your boyfriends and girlfriends, and then you get married, and then you start thinking about your environment and so on. Maybe you can you hear?
Yes, ma'am.
Okay, it sort of went off a little while. So, post facto clearance means that if you did not get, you forgot to get, you didn't know you had to get, you didn't want to get, you start your project, and then when people complain or when somebody comes to know, then you say, okay, now I am applying. Now, I told you already that when in the projects wrong facts used to be given, they never used to stop the project. Who is going to stop a hotel which is already built up? Who is going to stop an industry which is already built up? They'll give some kind of environment clearance, they'll put some conditions, and you will get it. So post facto clearance undermines the entire purpose of the environment impact assessment notification, which, as I started out by telling you, is based on the precautionary principle, on knowing in advance what will come and trying to deal with it. But a post facto clearance means getting just another chap, another paper from the government saying that you are fit and your industry is okay. So it is our earnest hope that with a large number of opposition that has come to the ministry, that EIA 2020 will be dropped, and that the problems that I have sort of highlighted, these are the problems we have shown to the ministry and said, try to correct the EIA notification 2006, make it a more worthwhile notification, deal with these problems so that we can have a better environment impact assessment done in the country. So, thank you very much. I hope you have understood all that I have put across.
Thank you so much, ma'am, for such an informative session. Ma'am, I would like to ask few questions by participants. May I?
Yes, please.
On page 29 of the draft, it is clearly mentioned that there is no scope for public complaint. How can we deal with this issue, which in some or the other way is against the very principle of natural justice?
See, that is the ministry seems to have got cold feet on allowing the public to have a say in projects. It feels that the public is raising too many concerns, and therefore it is trying to limit the extent of the complaints. So, in what way? Well, first of all, the notification is not coming to force. Until now, you can still make the complaint. But should that kind of notification still come in, then the only way will be with getting memoranda, campaigns, going to the government, going to your local authorities. But it's bringing the entire public mechanism and protest into a legitimate kind of form, because there will be no other way in which people can protest a project except by your non-violent protest, which government has said, block the roads, stop a project, and so on. Instead of allowing a legal outlet for people to vent their opinions and their grievances, the draft EIA is trying to stifle it.
Thank you, ma'am. What are your views on curtailment of requirement of conducting public hearing for various projects which have been reduced in the current draft EIA notification 2020? And ma'am, do you think it is necessary for notifying EIA notification in all Indian languages?
The first question, I think I have sort of made my views on public hearing quite explicit. I have said that public hearing should be held in all projects because it is good for the authorities to know what are the public concerns. Authorities sit in Delhi or in headquarters of the state. They may not know what is happening in a remote part of the state. They may not know comprehensively what is happening in different areas. And when you have a public hearing, you come to know what are the concerns of people, and you can try and deal with them. You come to know whether people are in favor of the project, and if they are not in favor of the project, why they are not in favor. You can make changes to a project. If the people's concern is that you will give jobs to outsiders and that's why they don't want the project, you can make some changes to ensure that that is dealt with. If the people's concern is that you drain out all the water from the area, you can make a provision for rainwater harvesting and say, I will not take public water, I will do rainwater harvesting. So public hearings bring to the fore all the problems that people face. And public hearings also serve to let people have their say before the project comes. I'll give you an example. There was a project called the Thapar DuPont's Nylon 6 project. This powerful company DuPont from the USA, along with Thapar, an Indian company, they wanted to set up a factory to produce nylon 6/6 rubber kind of things on a plateau. And they said the plateau was an empty, bare plateau. There was nothing happening there. All goats are roaming around. So they wanted to put up a factory. And the party got 24 clearances from every possible authority, export, import, state, central, local, wherever. Last, they came to the panchayat. But the people were opposed to that project. But nobody asked them about it. This is long back before the EIA, around the time, no, before the EIA. So people didn't want it. Why did the people not want it? They said the plateau is bare in a sense because, okay, there is nothing, no tall trees can ever grow on a plateau because the wind will knock it down. But on the sides of the plateau were their rich agricultural lands. They grew pineapple, they grew arecanut. It was completely dense with vegetation, all grown by the people. And they said, if you put a factory on the top, you will destroy our entire livelihood, because the factory, you will cement it, so rainwater will not percolate. And if your rainwater does not percolate, our crops will not get any water. They'll be starved of water, apart from the fact that there will be pollution. When it came to the panchayat, because the whole panchayat ghar was surrounded by villagers who said, we don't want the factory, the panchayat said no. And they could not put up that factory. They eventually went away from Goa. There is a long history behind it. There was a police firing and so on. But the point is that you took everybody's permission, but you didn't care about the people who would be most affected by it. And when the time came, the people said, we don't want this factory in our area, because you will destroy this whole thing. So is it not better for you to know in advance what are the objections, so that you can deal with them, or you can change your project, or you can say, this is too difficult, I don't think I want to put this up, I'll do something else, or I'll go somewhere else. That was the answer to your first question. The second one, what did you ask me? I'm sorry. What is your second question? Hello? Hello?
Hello.
Yeah, what was the second question?
Ma'am, her second question is that it is necessary that in a 24 language the EIA draft should be published.
Yes. No, it is the draft notification, since there is so much opposition coming from an English speaking public only, is it not necessary that the notification should be translated, so that others also who do not speak English fluently can also understand the consequences of the impact of this notification? Otherwise, you're taking only one section of the population. You're taking only the educated section, and ordinary people, because ordinary people will consult someone if they understand what is in the notification. So I do think that when there's so much opposition in one, which is coming in a language understood by educated people, why should we leave others out also? It should be translated.
Ma'am, one more last question.
Yes.
Should we have an act for a EIA rather than a notification?
What would be the advantage? See, acts can be amended, and in the same way as notifications can be changed. There is nothing particularly sacrosanct in that sense. But an Environment Impact Assessment Act, you would have to repeat all the provisions of the EPA, which are very good. So I don't see a great reason in making it into an act, because it is not that you cannot change an act, you are able to change all acts. And when you have the Environment Protection Act, which is a very broad act, and it's an umbrella act, and it contains everything, then anything that the EIA notification might miss out, you may still perhaps be able to refer to the Environment Protection Act and try to use it to get some protection for the environment. But if it's a standalone act, then it must be compact in itself. So I see it an advantage to have the broad umbrella act with its broad definition, rather than restrict it only to industries and processes which are impacting the environment. Because if you see, EPA doesn't say if you impact the environment, then you are covered. It just says you're covered. You're covered. By just breathing, you're covered. By just living, you're covered. By even a microorganism, you're covered. So EPA is so broad that it's difficult to say that I don't want to be under it and I want to be standalone.
Thank you, ma'am. Yes, Bijal.
Thank you so much, ma'am, for your such great views. Now, on behalf of Bharati Vidyapeeth, deemed to be University, New Law College, Pune, Environment Cell, and the entire fraternity of the institution, I would like to express my sincere thanks to Padma Shri Honorable Advocate Norma Alvarez, ma'am, for gracing the occasion and sharing with us her thought-provoking opinions on environmental impact assessment and explained us about the each facet of environmental impact assessment, including all the notifications. I would like to express my deep gratitude to our beloved principal, ma'am, Dr. Bhagyashree Deshpande, ma'am, for her motivation and enthusiastic support in organizing this event. I would like to thank Dr. Jyoti Dharma, ma'am, Head of Environment Cell, for her guidance and moral support, and Dr. Jayashree Kandari, ma'am, Faculty Coordinator, who have been the pillars of strength and guided us throughout. I am happy to express my thanks to our staff members and participants for making today's event successful. And last but not the least, thanks to our technical team. Thank you so much, one and all.
Now, it is a request to all the members, those who are on a Zoom, please on your camera so that we can have an online photograph. So it will be in our memory. Ma'am, please, it will take only 1 minute. All the members, those who are on this Zoom link, please on your camera, everyone. Anmol, on karo. Hmm? तुम नहीं दिख रहे. Done? Okay, it's done. Thank you very much, ma'am.
Thank you.
Thank you.